Go ahead, attorney.
Thank you. Good morning. My name is Brian Monahan. I'm an attorney, and the Board of Trustees appointed me the last time we did this session to serve as hearing officer in this proceeding, and that appointment remains in force and effect. It has not been rescinded. Just to reiterate, my role today will be similar to a judge in managing the conduct of this proceeding and the flow of the evidence. As I've stated before, I have no vote in the outcome of this proceeding. My role is simply to assist the Board of Trustees. This is a quasi-judicial hearing, similar to a courtroom proceeding. So it's going to look a lot like a hearing you would see in a civil courtroom. The attorneys here are here to represent the employee and the manager. If they wish, they will present an opening statement. I will accept in a few moments argument on some of the evidentiary issues that we have open. Then they will present witness testimony and offer up evidence to the board for review. After the evidence is closed, there will be an opportunity for the attorneys to present a closing statement. We will not take questions from members of the public. I understand that's different from a standard Board of Trustees meeting, but this is a different proceeding from that. Employment hearings are usually done in closed-door executive sessions. Here, the employee has requested a public hearing, and the board is going to honor that request. While it is an open meeting, this does not change the nature of what is happening. Some important guidelines: if you have not already done so, please turn your cell phone to silent. We don't want any interruptions. We have important work to do. The hearing is on Zoom as well for your convenience. This meeting is different from other Board of Trustees proceedings because it's quasi-judicial proceeding. This board will consider the rights of the employee. When we use the term quasi-judicial, it means that this board, while not an actual court, it is conducting a quasi-judicial administrative review and is tasked with acting in a judicial fashion. Because of the sanctity of this proceeding, I am asking everyone to respect the rights of the employee and the employer and the challenging work we all have to do today, and refrain from making any comments or suggestions, shouts, rolling of the eyes, responding to witness testimony, or anything like that. The board requests everybody's right to be present, and we also ask that you respect the legal rights of those who are here today to work at this proceeding. We will require anybody disrupting the proceedings to leave. I know there are strong feelings about this matter. You're free to exercise your views anywhere you want outside of this judicial type proceeding. Here, the board is obligated to hear simply the evidence presented today, and the board will not permit outside influences on the board's decision-making other than the evidence presented here in this room. We will take a break at approximately 10:30 for perhaps 15 minutes, and then take a lunch break at noon. And assuming we're still going in the afternoon, we will take an afternoon break. And I anticipate if we're still going, we will end the proceedings at 5 p.m. today, and we have reserved tomorrow in case we need to do that. There are allegations of conflict of interest, and the Board of Trustees has responded with written statements, which will be available. I have the originals, but not copies. I can share those with you to look at, but don't have copies to hand out. You can take a photo of them if you wish, and I'll be able to email those to you perhaps later tonight or tomorrow. Some housekeeping requests for counsel. I understand there might be a witness or witnesses appearing by Zoom. We're going to rely on counsel to manage that, and we want witnesses to be sequestered. So if they are going to testify, they should not be in the Zoom. You should be reaching out to them to tell them when to come in, and we're going to rely on you for that. We can't be monitoring the Zoom. Okay.
There's only one witness, Your Honor. Oops, excuse me, I'm used to being in court.
Yes.
There's only one witness, Attorney Monahan, who will potentially appear on behalf of Mr. Duffy, and he's been clearly instructed to not join Zoom until 5. text him, invite him.
Okay.
So no concerns there. I guess while we're on the topic of recusal, I just want to confirm there isn't any member of the audience who might potentially be a witness that Attorney Grass calls and asks for the same ruling to be applied to
Okay.
Mr. Swanson.
Okay. Is that the case?
Pardon me?
There's no witnesses here in the room on your part. Okay, thank you. I think then to begin our work, what we should do is perhaps ask for an opening statement from each of you, and then there are questions about the evidence offered. So if you want to, what I think we should do is probably ask you for an opening statement, and I would begin with you since you're the appealing party on behalf of the employer, Attorney Frass. Give us your opening statement. Attorney Hoax can give an opening statement. And then I think what might make the most sense is to go through the exhibits that you have proposed to be offered. If we could ask you for an offer of proof on those, and we'll allow Attorney Hoax to respond to them. And then I anticipate the board will want to deliberate to consider that stuff and then come back and address how the board's going to handle that. All right, so we'll turn over to you. Thank you.
Thank you. Good morning.
Good morning.
So here we are, almost a year later. I didn't know what to expect the first time that I came here. I anticipated, as I always do, it's kind of my Achilles heel. I always assume that if people are given the right information, that they will make logical and reasonable decisions with that information. And it's very naive, and you'd think I'd know better by now, but I'm usually disappointed, and this was no exception. What happened here did not comport with any just cause removal process. It was reversed by the court. Everything that was done here the last time has been reversed in terms of the decision. There were many clues last time that things were not going to, that the deck was basically stacked against Chief Swanson, and that remains the case. The clues last time were, there was a lot of talk about you can't criticize the manager. He's not on trial. There was a lot of talk about withholding evidence. There was no evidence was produced. There was no transparency. There was efforts to hide and obfuscate evidence. There were, at the hearing, I was threatened to be removed for things that would never be allowed in a court of law. Chief Swanson's husband and family were removed. There was rampant unsupported hearsay. There were so many things that did not comport with justice at the first hearing. And I really have no reason to believe it's going to be any different today, based on everything that has happened. And here we are. But I should say, here I am. Chief Swanson isn't here. Why isn't Chief Swanson here? He's not here because he is on medical leave, full workers' comp, no capacity to work leave from his job because he had surgery on December 22nd, and he's still recovering from that surgery, and he is not able to be here. And how did he get that injury? He got that injury in the course of his employment when he risked his life for this town and was shot in the line of duty and fell and injured his back. And here we are a couple of years later, and he had to have surgery. You have you're compelled that he has to be here, and he can't be here. And you are compelled that a doctor has to sign some kind of special note. He has a workers' compensation, full disability, no work capacity, no sedentary work, no light duty work. But yet he was told that if he didn't come to this hearing, that he basically had to, and the only reasonable accommodation would be that perhaps he could testify from bed, which was not reasonable at this point in his recovery process. He hasn't even started physical therapy. But you commanded he be here, he's not here. I'm here on his behalf. I'm here under protest. I'm here under protest for his rights because they have been denied. His due process rights have been denied. He cannot be here to confront the situation. He can't be here to participate meaningfully in his defense. He cannot even watch the hearing because of his condition. So here we are. And as I said, I had been optimistic that justice would prevail. But because there was no evidence last time, and there's even less this time in terms of finding just cause for Chief Swanson's removal, all my hopes were dashed. First, I thought, okay, this is just one individual, one person who obviously has inexperience as a manager, who has some agenda, some personal agenda, who's driving an erratic train out of control, and that surely he will be stopped. That is what I originally thought. Then it turned out that the people with the authority to stop that train were unwilling to do that. No one who has come in has been able to redirect the route that the train has been taking, and it's on a collision course. It collided once, and it's going to collide again, and no one seems able or willing to stop the one person who has spearheaded this entire situation. In fact, he's been rewarded. He's not only has he not been stopped, he's been rewarded. He's been rewarded with bonuses. He's been rewarded with a new contract with $176,000 in increase in salary increase. If I had any hope after the last hearing and what happened, when the order came out, it was absolutely clear that there was nothing that could ever be done to obtain justice with this board, because the order was insulting, it was gratuitous, it had character assassinations. There were things that no professional order should ever contain in that. It violated all standards of decency for a respected, honored police chief who had risked his life for this community. It was gratuitous, it was inflammatory, the commentary was off the charts in terms of trying to tear him down. And that became public. You release that, it became public, and his reputation has been smeared throughout the community because of this. The most important thing is that in that decision that attacked his character, there was not one instance of any behavior that rose to the level of just cause for termination. And you didn't even think that there should be just cause in that hearing. You told Chief Swanson that he could be eliminated, he could be removed from his position, he could be demoted without just cause because he was still employed by the police department, so why should he be complaining? He shouldn't need to have just cause to be removed from his position because demotion isn't termination. It's not the same. That was the argument. Obviously, it was a bad argument and it was reversed because just cause is needed. But the most important thing is the judge only looked at the fact that you didn't even consider just cause, did not even look at the fact that demotion in itself is not a legal remedy. So once again, you're considering demotion. You're going down the path of injustice because he has a contract. The contract says he is a chief. You can't take someone in a contracted position and just tell them they're going to be something else. Would you make Manager Duffy a secretary if you didn't like his performance? You can't do that. But you're going to do that because that's what we're here for. And the other thing is that in terms of all these legal theories, he's been told even now that there should be no just cause for his removal. Even now, up to this point, even after the judge ruled that it had to be, the arguments I'm seeing are no, any minor violation of the personnel policy should be reason to get rid of him. So that's where we're at today, and it's all unlawful, and it will be reversed again. We're confident of that. When the judge reversed the first unlawful ruling, he did not instruct you to hold a hearing. He gave you the option of whether you wanted to do another removal hearing. There was something in the media recently that we requested this hearing. We did not request this hearing. We did not request this hearing because we didn't think there should be a hearing. He should have been reinstated immediately. Instead, we were summoned here again so that you could once again demote him. And here we are for round 2. And as I said, I do not believe that there is any chance, less than 1% chance, that Chief Swanson can have a reasonable, fair hearing in this context. One of the things that will be addressed apparently is the motion I made to recuse some of you. All of you have been defendants in a civil lawsuit that was brought by Chief Swanson. 4 of you got out on absolute immunity, which means that no matter what kinds of bad faith motives you might have had, no matter what you might have done to discriminate, you can't be held liable. One of you is still, Ms. McElroy is still a defendant. She has an absolute conflict of interest. Any decision she makes today is going to impact that civil case. And yet there she is, sitting here. We have Trustee Blakeman, who have also asked to recuse herself. She's claiming she can be fair and neutral. She gave the finger to Chief Swanson's husband. And yet she sits here claiming that she could be objective, there's no problem, and there is a problem. And any normal, reasonable person looking at the situation would determine that this is not a fair and neutral panel. It's preposterous to claim otherwise. So again, I came here to protect Chief Swanson's rights without any expectations. And most of all, I came here to have everything be out in the public. In the words of Elizabeth Warren, when you have no real power, go public. Really public. The public is where the real power is. And that is why we are here, to make everything apparent, transparent. You will hear a lot of efforts to keep evidence from you. And that is what this is all about. And as we go forward, the charges that were there the first time are the same ridiculous charges they were the first time. Nothing that rises to just cause. You yourselves have already determined there was no prior notice and no one act that warranted dismissal. That is the definition of just cause. You have already found there is none, but yet somehow you're going to reverse your contradict your former decision and now find it. So we're also here today for another purpose. The question I am often asked, most frequently asked question that I am asked is why? Why is this happening to Chief Swanson? People who look at the allegations and see that this is so minor, and why would this be happening to him? Why is this chief being treated this way? And the evidence in this case will show why he's being treated this way. It's something no one wants to talk about. It's something that is unpleasant to talk about, and that is homophobia, and that is discrimination and bias. Those are the reasons that Chief Swanson is targeted. Everybody thinks it can't happen in Woodstock, but clearly it has happened. The only gay police chief that Woodstock has ever seen has been treated in a way that no heterosexual police officer or police chief ever would be, ever could be. And there's different standards. Excuse me, I need a little water here. My mouth is really dry. As I said, he's been treated in ways that are different than other officers, different than other officers in the department. He's been held to different standards. There are different criteria. There's different levels of respect. The respect that he has been withheld from him would never be the case. Now, there is explicit bias where people are intentionally, and there's implicit. Probably both of those are at play here. No one is going to come forward and say, oh yeah, we don't like Chief Swanson because he's gay. That's not how bias works. It's the underlying attitudes and stereotypes that influence the perceptions, actions, and decisions of people, underlying negative stereotypes about gay people. And there's no question here that Chief Swanson has been subjected to bias. In fact, the unequal policies that have been applied, Manager Duffy applies different standards to himself than to Chief Swanson, than to other employees. Unequal treatment. We look at indirect evidence like that because no one's going to come forward and say, yes, I don't like him because he's gay. So we look at the indirect evidence. And what does that mean? It means things like, as I said, the unequal treatment of him, the underlying stereotypes that have been applied. Think of some of the things that have been applied here. The stereotype, oh, a gay chief has less leadership ability because he's gay. What heterosexual officer has ever been scrutinized like Chief Swanson for his clothing, his hair, his demeanor. That would never happen to a heterosexual officer, never by his heterosexual counterparts. And then he's been vilified for things like taking taking vacation leave, to go watch his husband in court. Vilified for that. And if that were a heterosexual person, he would be considered supportive and sweet. Instead, it's considered one of the grounds for discipline for him that he did that. But mostly the overwhelming lack of respect, lack for a honored veteran who has served this town faithfully for years. And when we're talking about things like somebody coming in and saying they don't like his socks. Well, he denies that he wears mismatched socks, but perhaps his socks were bold. Perhaps they were bright. Perhaps they were something like this. Perhaps they were too gay. Perhaps that was the complaint. Those kinds of things indicate bias. They indicate homophobia, the kinds of ways he was treated that are different. You'll have more evidence this time that the allegations against him are bogus. We have a police expert who has provided an opinion, somebody who was the chief of police for an Upper Valley.
Attorney Monahan, I just want to note that I have objections to certain evidence being presented to Attorney Frost. I'm hesitant to interrupt her opening, but given I'd like to maintain those objections, I just want to note that for the record. Please.
Her objections are noted for the record. We'll let her continue, and there will be an opportunity to address the evidence.
Thank you.
As I said, and as you've just heard, there will be many objections. There will be many attempts to prevent you from hearing something like that. Why would you not want to hear about a police chief who was police chief for years in the major Upper Valley chief in Lebanon, I believe, and he is now a consultant, but we don't know him. We just asked him to give us an opinion, and he gave an opinion. And the opinion was that the investigation was flawed, that what Mr. Duffy did was flawed, that there's nothing here that would rise to the level. This is an objective, neutral opinion. It's the only objective, neutral opinion that you have ever received from a police person. Mr. Burgess gave you a report, but he didn't make any conclusions that Chief Swanson violated anything. He just gave his facts to Manager Duffy, who is not a police officer, has no experience, but somehow came up with this idea that policies were violated and he should be terminated immediately. So the second frequently asked question that I get is, why is Chief Swanson pursuing this if no one wants him here? That's the second thing that I'm asked most often. And first of all, it's a myth that no one wants him here. This is a small group of vindictive, hateful people that are trying to remove him. He has much support in the community. He has much more support in the police force. This is a pervasive homophobia from a small group. It is not the reflection on the community as a whole, and I want to make that clear. And if there were anything, first people thought there must be something. Why would they be doing this? There has to be something. And if there's something that was terrible that happened, they would obviously support his removal. But that's not the case. Everybody has the facts by now. They've been well publicized. There is nothing here to warrant removing Chief Swanson. Nothing at all. And in terms of why he's fighting for justice. He's not just going to go away and allow this to happen to him. Maybe some people with less strength of character would, but he is not. He spent 9 months in Afghanistan, and during that time, the Taliban was targeting him, but that wasn't as stressful as being targeted personally by all of you, by Manager Duffy. Being targeted personally, this has been a terrible, horrible experience for him all year. And it's one of those things, like, as I said, it's not everybody, it's a small group. And it only takes one influential person, like the Salem witch trials, to point a finger at someone.
and to make accusations at that person. And that person is usually a marginalized person of the community. One person pointing fingers. It's all it takes to create a mob mentality where other people get on board, start gnashing and wailing and falling over themselves to point the finger at him as well. That's what's happened here. Hysteria has gone unchecked, and panic and the lack of logic that has happened is overwhelming. And when that happens, it causes the legal principles and due process to be abandoned. And that is what has happened here. The mentality destroys the foundation of justice, and it turns it into a warped alien concept and that's what we're dealing with. We are not having justice here. Fortunately, however, unlike the witch trials, we do now have an appellate process. Somebody who will oversee this, a real judge, a real court of law, applying real facts to real evidence to come to the right decision. And ultimately, that's what we're relying on. That's why we're here, to create an appellate record so somebody with greater power can make the right decision and apply the right law. Thank you.
Thank you, Attorney Host.
Thank you. As an initial matter, we didn't request this hearing. We view the trial court's opinion remanding this matter to require application of a legal standard to the facts you've already found. I understand you'd like to give Mr. Swanson the opportunity to present additional evidence and for Mr. Duffy to rebut that evidence, but we're here at your request as well. And it wasn't Mr. Duffy who chose to make the trustees' first decision public either, nor did Mr. Duffy oppose Mr. Swanson's request to continue the hearing due to his alleged unavailability. I do know he did manage to make it over 100-paragraph long affidavit and submit that, but I'll reserve my comments for that when we get to the evidence. I'd like to focus on the facts rather than rhetoric. And the best evidence regarding this employment decision has already been found by the trustees. Paragraphs 41 and 44. Mr. Swanson used his work email to send 6 videos to his spouse without any request for legal advice. Paragraph 46. Mr. Swanson asked dispatchers to sign him in on duty at 6 a.m. but did not appear in the office until several hours later. In reference to another dispatcher, he said, quote, pardon my strong language here, tell her to stop fucking calling me, end quote, based on a work-related issue during non-work hours. Paragraph 48, 2 undertrained officers were allowed into the field. Paragraph 49, 2 officers with level 2 certifications were allowed to work regular shifts with no supervision. Paragraph 50, Mr. Swanson signed off on Sergeant O'Keefe's use of force training despite being a few hours short. Paragraphs 51 and 69, Mr. Swanson was out of uniform, a factor that effectively contributes to his ability to serve as a role model. Paragraph 52, his schedule was variable. Paragraph 55, he was regularly absent without employees knowing where he was. Colleagues did not know where he was. Paragraph 57, sometimes he communicated he was going on personal errands and did not log his absences, even when he was designated as a backup officer. This is crucial. Paragraph 58, dispatchers attempted to reach him, but he didn't respond to their request to communicate. Paragraph 59, he failed to complete Valcor logs. Paragraph 61, DHS agents were invited to review video footage of a suspect examining the interior of a school building. Mr. Swanson did not join the meeting, even though he was just a mile down the road. When Sergeant O'Keefe said most folks were upset, he responded, again, pardon my language, quote, fuck them, I don't care, end quote. Paragraph 64, the time he was scheduled to appear in traffic court, he chose not to appear without providing any notice, giving a freebie, in his words. Paragraph 65, he conducted personal business on work time. Paragraph 66, his messy office indicates he's not able to serve as a leader or role model. Paragraph 67, he made dispatcher Sutherland feel threatened, intimidated, and uncomfortable. Paragraph 69, he did not complete a death investigation for a death that occurred in January 2024, for which he was the primary officer. Paragraph 72, he discussed discipline for the officer given by Sergeant O'Keefe for failing to follow his directive to pick up a parking meter attendant. This was for Mr. O'Keefe, gave the impression of an atmosphere of leniency. A culture of slight deviation can build up over time from policy. Paragraph 75, the New England Police Benevolent Association Local 416 and 431 both approved a no confidence vote. Paragraph 94, while on paid administrative leave and relieved of his duties, Mr. Swanson was instructed not to access secure areas, but came into employee offices and provided a copy of a letter. Paragraph 95, Dispatcher Sutherland and Dispatcher Supervisor Taryn were upset, and Ms. Sutherland felt threatened, intimidated, and uncomfortable. Paragraph 96, Dispatcher Taryn believed Mr. Swanson would retaliate against her. Paragraphs 113 to 114, Ms. Sutherland, Ms. Taryn, Ms. Murphy, and Mr. O'Keefe indicated they would leave if Mr. Swanson were to return as chief. You can't look at any of these factors in isolation. Some may have more weight than others, but viewed in their totality, these facts are more than sufficient to conclude that good cause exists to remove Mr. Swanson from the position of police chief under 21 VSA section 1932. That's the statute that the trial court directed needs to apply here. Removal under that statute is equivalent to, or I guess to say it another way, termination under the employment agreement is an equal or lower to standard than the statute. So satisfying the statute satisfies both standards. And to address another comment by Attorney Frass in her opening statement, there is not a scrap of evidence regarding homophobia in the record before you. This wasn't even mentioned at the first hearing, and there is no evidence in that whole record, all the transcripts and all the exhibits, or indeed any of the many that Mr. Swanson seeks to admit today, that has explicit or implicit bias reflected in it. And I just want to say that, make that absolutely crystal clear. You can make that allegation, but there's not a scrap of evidence, and facts are what matter here. You're the ultimate fact finder. Since Attorney Frass mentioned the law briefly, I would like to just say that the trustees should rely on case law specifically addressing 21 VSA 1931, 1932, and police officers. Cases arising from grievances before the VLRB under collective bargaining agreements have a totally different statutory framework and different policy needs. Those cases have not addressed the specific question of police officers, which occupy a unique role in society. The Supreme Court of Vermont has stated, generally speaking, we require higher standards of conduct from our law enforcement officials than we might of people in other professions. I'm quoting Turnley versus Town of Vernon, 2013, Vermont 42. Plus, the Supreme Court has held that the statute does not preclude termination for cause pursuant to 1931A based on factors not delineated in 1931A, including when an officer is unable to perform the duties of his or her employment. Even so, if you're inclined to consider the VLRB standard, the cases boil down to whether dismissal is reasonable. In applying those factors to the conduct that you've already found, the facts that you've already found, for which there is not many instances any dispute at all about what actually occurred, those facts support that removal is eminently reasonable here. Thank you.
Thank you, Attorney Hoaxed. I think now, Attorney Frass, do you want to perhaps walk us through the evidence that you've proffered and give us a brief offer of proof on each, and then we'll ask Attorney Hoaxed to address them, and then the board can deliberate. I feel like that's the most efficient way to do this.
Okay. Don't I need to know what she's objecting to on this? You want me to pull out her
She did put it in writing.
You
so-
did, should I get that and go through each one? How about I just go through each one and we'll
Yeah.
deal with it that way?
That's what I would.
Yeah, that'd probably be easier. So, oops, what are you doing here? So the first several exhibits are affidavits that you have already ruled, Attorney Monahan, that we could submit affidavits to this tribunal. So we in fact did obtain affidavits. The first one is Richard Mello, the police expert, with his CV and his report. He has attested to all of them under oath that they're all his opinions. And I did read the objection to that. I don't understand it. I read it, but I don't understand it. It's an affidavit, it's under oath, it has opinions. This whole idea that somehow, because he's not an investigator in Vermont, he didn't do something, but he didn't do an investigation. He did an opinion, he was a consultant. He doesn't need a Vermont private investigator license to do that. He was hired to provide an opinion about the facts, about what a reasonable police chief would view the situation and act. So I don't think there should be any problem. I will also point out that Investigator Burgess's report was introduced last time. It wasn't even under oath. It was just introduced it had facts. There was no conclusions, but there were all these various facts. So I don't see what the problem would be to have the affidavit of Richard Mello. The other thing is, I don't know why it would be objected to, because in the pre-hearing conference that we had, you told us, Attorney Monahan, that the trustees wanted to hear evidence. They wanted to hear whatever evidence we had. They wanted to see what was available. And Attorney Hesht has told me that she represents the village. She's not here to represent Mr. Duffy's personal interest. So if she's here representing the village, you're saying the village wants to hear evidence, I don't understand the basis for why she's objecting.
Okay. Do you want to address that one, and we can go basically like
Sure. I've made a general objection on relying on affidavits. I did present that prior to the hearing. I understand the trustees have decided to accept affidavits in lieu of live testimony. And I had in mind individuals who would not be able to attend the hearing to present live testimony. The ability to cross-examine witnesses is absolutely essential. It's the cornerstone of the adversarial American justice system. And there's no evidence that Mr. Mello is not available to appear remotely and to submit himself to cross-examination. And so I'll just say that applies across the board, that I request that individuals who there's not any proffer that they're unavailable or unable to testify should be required to be subject to cross-examination. Or at a minimum, the trustee should make a negative inference about the probative value of such documents, because they lack the evidentiary protections of cross-examination, ability to observe nonverbal behavior, and being sworn. On the topic of Mr. Mello specifically, expert opinions carry higher weight because of the imprimatur of expertise. And we're not trying to exclude his opinion because we are trying to hide evidence from the trustees. He's offering an opinion on the ultimate legal issue without any legal training. That is part of our objection. Whether there's cause to remove based on the facts as found by the trustees is a question of law for the trustees to address with the assistance of counsel. There can be no dispute he is not a lawyer with legal training. In addition, his CV effectively holds himself out as a private investigator, and by accepting his opinion, he would be potentially running afoul of Vermont laws regulating required licensure for private investigators. At a minimum, expert reports are not generally admissible evidence. In other contexts, I recognize there's some latitude for hearsay here, but an expert report comes with a higher amount of weight often due to the qualifications of the person giving it. And so, you know, we're not saying don't let him give his opinions. We're saying he should be required to testify like all of the employees who came here despite significant public scrutiny and fear of retaliation, and looked you in the eyes and looked Attorney Frass in the eyes and were subject to cross-examination the first time around.
Thank you. Do you want to respond to that?
Yes, I do. First of all, we relied on the ruling that was made. Attorney Hesh did make an objection to presenting evidence by affidavits. There was a pre-hearing ruling that they would be allowed. We relied upon that ruling and therefore got the affidavits. Witnesses cannot be here for a variety of reasons. It's really not the point about why they can't. If you look at Attorney Mello's notary, he's actually in Texas at the moment on a family issue. So there are many reasons why witnesses can't be here. And that isn't really important because we relied on the pre-hearing ruling, which was already established that we could in fact present these affidavits. And the other issue is that, yes, we have a transcript from the first hearing, but I asked for those witnesses to come back here so that they could be re-examined with new information. I was denied that because this board does not have subpoena power, which I understand. But I also asked Manager Duffy, through his attorney, to voluntarily, since they all voluntarily came at his request last time, I asked if they would voluntarily come at his request this time, if he could ask them. And no, he can't, he won't. He will not ask them to come back. And I have that in writing. So there's no prejudice here. We have to rely on what they're submitting, they have to rely on what we're submitting, and that's quid pro quo.
Okay, thank you. Shall we go on to the next one?
Okay. Well, these will all be the same argument around the affidavits. The next one is an affidavit of Robbie Blish. Robbie Blish was the former chief of police. There had been an issue that was brought up in the first hearing about the allegations that Chief Swanson had inappropriately consulted with his husband and shared videos. Robbie Blish was the former police chief, and the affidavit speaks to his own behavior and actions and the fact that he himself had done similar things and that that was not a violation, and that he does not find any violation in what Chief Swanson did, and that is his professional opinion based on his experience. So that is also submitted, again, on reliance of the prior order that we could submit affidavits. And he's clearly not available. He's, I think, Tennessee. I can't remember where he is. Let me see where it is. Tennessee. Right. So there he is. And then we have the next one, affidavit of Joseph Swanson, which is...
Can we just...
Oh, I'm sorry.
Any objection?
Oh, yes.
Respond. So I will assume that I may have a standing objection based on my arguments that concern multiple documents. Okay,
Understood.
thank you. So the only thing I want to specifically say about Mr. Blish's affidavit is that this could only possibly be relevant to the question about the emails between Mr. Swanson and his spouse regarding the videos, police videos he shared of an accident, and those speak for themselves. They've already been considered by the trustees, and this, even if we accept for the sake of argument that Mr. Selden did at some point have a formal engagement with the department, that doesn't prove that on November 8th, 2023, Mr. Swanson was acting under the umbrella of the attorney-client privilege, or that there's any evidence of legal advice of seeking legal advice, which would be required for the privilege to attach as a matter of law.
Thank you. You want to go on?
Moving on. Affidavit of Joseph Swanson, that's the next one, obviously. Chief Swanson couldn't be here, so this is the best we could do. I worked extensively to put this together, consulting with him, as it says at the beginning, in brief intervals until we could get this. A lot of the things were incorporated from prior affidavits that we had filed in conjunction with the Rule 75. So we were able to put this together for him. It deals with the things he would be testifying if he were able to come today. These are all things that rebut the allegations that were made against him. These are things that prove that a lot of what was said before turned out to be absolutely disproven by objective evidence. For instance, this allegation that he had entered the police department as a, quote, ruse, which I don't even know where that came from, but we didn't have an opportunity. We never expected to see a decision accusing him of something so outrageous. So we did not, at that point, even know enough to counter it. And at this point, we do, so we have the evidence. We have the fact that 2 days before he ever received that notice that he brought into the police department, that I asked for permission through Mr. Duffy's attorney. I asked for permission 2 days before Chief Swanson ever received that notice. And we can prove that he did not receive that notice until February 20th. We can prove through the evidence, which is one of my exhibits, that I asked 2 days earlier for permission for him to enter. I said, I assume there will be no problem with this. There was never a response for 2 days from the attorney on behalf of Manager Duffy. He then texted Sergeant O'Keefe and got permission, entered. So we can prove that it was not a ruse. It couldn't be a ruse because he didn't even have the decision when he was asked to get training materials. So that was manufactured out of thin air. And we have proof that that was not, in fact, what happened. The next thing that he would have testified about that we also have proof are these, and you heard it, actually, Attorney Hesh just said it again in her opening, that he was accused of not attending the only time he had traffic court. Well, we have records, that's not true. It's absolutely not true because we have records that he did in fact attend traffic court. So it couldn't have been that he refused or didn't attend the only time because we have the actual records. He's responded to some of the other allegations that were shown in the decision to be false. He's given some explanations that he testified, let's not forget, he testified at, I think, midnight on that last hearing. So there were things that didn't get addressed because we weren't going to be there till 3 o'clock in the morning. So he's had an opportunity now to go forward. And there, as I said, there were things that weren't even brought up against him in the first hearing that he had to, things that weren't brought up against him in any of the previous letters that he received that he now has to respond to. And one of them was this bizarre allegation that he allowed untrained officers into the field. And that's a very serious allegation. He's presented some explanations for why that's absolutely not true. He would never do such a thing. It would be a serious violation, and there's no evidence whatsoever to support that. The same with, he had no idea that Sergeant O'Keefe was going to come in and accuse him of somehow falsifying records, training records for him, and which also begs the question as to why Sergeant O'Keefe would even be allowing such a thing if that were true, and it's not. So Sergeant O'Keefe now has the opportunity to address that he in fact did not do that, and there's proof that Sergeant O'Keefe already had most of the hours he needed. So we have some more evidence. And again, he's had an opportunity throughout the affidavit to respond to various things. Now, I know that there's an objection to the part of this affidavit that talks about what happened after he was unlawfully demoted. And I understand that that's also the objection to some other exhibits. my argument is that we're talking about bias here. So what happened in the overall context to Chief Swanson, how he was treated, even while he was unlawfully demoted, speaks to that question of homophobia and bias. Because during that time, he was treated, again, in ways that no officer has ever been treated by the Woodstock Police Department. He was put out on involuntary leave with this fake allegation of shaky hands. He was told he had to relinquish his gun and badge. He couldn't access email because he had shaky hands. There was a lot going on in that time that was completely unethical and unwarranted, and evidence of homophobia. So that is why those allegations are in there, explaining what happened to him, explaining why it is that we believe that these things are relevant to the whole picture of what happened to Chief Swanson during his tenure as an unlawfully demoted police officer.
Okay, thank you. Just before you go on, I just wanted to ask a procedural question in terms of, is it your intention that basically you'll offer the exhibits into evidence and then the board will consider them? And I mean, there's not going to be any other discussion aside from this right now, I presume.
Correct.
Okay, just wanted to get that straight. Attorney Hawes?
Just as a heads up, my last name is pronounced Haste. I'm not
Oh,
offended if you
thank you.
mispronounce
I
it,
didn't know.
but it doesn't look like how it's spelled, so if you don't remember, no problem. But it's a long A sound, like Haykst. So I want to start, I have an overarching argument here that applies to Mr. Swanson's affidavit about all evidence post-stating the first decision by the trustees. So again, I'll just present it, but on February 16th, Attorney Monahan wrote that the hearing would be limited to the 3 letters prior to the March 2025 hearing, specifically the notices from January 10th, 2025, February 20th, 2025, and February 23rd, 2025, all of which were admitted into evidence and are in the big white binders that my office supplied. Obviously, anything that occurred after the first decision is not a basis for discipline relied on by Mr. Duffy. Nor is Mr. Duffy seeking to remove Mr. Swanson as chief based on any conduct that occurred after the trustees' first decision. It's just way beyond the scope of this hearing and has no relevance. In addition to that February 16, 2026 ruling, I understand there was another ruling prior to my involvement on August 29, 2025, in which Attorney Monahan wrote the parties could present evidence as long as it was limited to the time period for which Mr. Swanson served as chief. To the extent there is evidence about any issues occurring outside that time period, it would not be relevant. It's highly prejudicial to, in light of these rulings, to submit a stack of, allegations concerning months after the first decision, given these rulings at close to 5 p.m. on Friday, when they have absolutely no relevance to the question, the original question the trustees were considering and the question the court has directed, which is there cause to remove Mr. Swanson from chief under Vermont law and his employment agreement? And indeed, Attorney Frost has strenuously argued that conduct that occurred outside the scope of his tenure as chief cannot be held against him. To be clear, I don't think any evidence Attorney Frost is trying to submit supports one iota that anyone was acting out of an improper motive of any kind or out of bias, implicit or explicit. But given the scope of what we're here to do today, it would be hugely prejudicial and unfair to massively expand the scope in light of Attorney Monahan's prior rulings in writing before this hearing. So that concerns a big chunk of the affidavit starting at paragraph, I believe it's 73. And the rest, I've detailed specific objections in my letter. I don't know how useful it would be for me to just simply repeat them, but the thrust of almost all of my objections is that the this is purely cumulative, that this is just simply disagreements from Mr. Swanson with the facts that have already been found without anything truly new. Therefore, I'm going to rely on my more fulsome explication in the interest of time, which I trust the trustees will read or Attorney Monahan will advise me to consider.
If I may respond.
Thank you. Yes.
Yes. Well, if in fact, as Attorney Hast, is that correct? Am I saying it right?
Haste,
Hast.
like with a hurricane. It's okay if you don't
Hey.
pronounce it.
Okay.
Haste.
Okay.
Thank you.
As Attorney for Manager Duffy has indicated, if in fact they are viewing these as prejudicial, that's absolutely all the more reason that they should be admitted for the reason I just stated, which is bias. Because if they are prejudicial, that means they do not want them to be seen because they don't make the manager look very good. So therefore, and we are not going outside of the first allegations. Yes, there are no new allegations against Chief Swanson. This evidence is not to prove any new allegations or to deal with that. They are to prove the culture and pervasive environment of discrimination that Chief Swanson has been subjected to. So they are relevant for the overall purpose of showing what has been going on and what Manager Duffy has been doing to Chief Swanson, whether he was as a chief or as a demoted officer. So that is the relevance.
Thank you. Let's go on.
The next affidavit was from Attorney Nicholas Selden. The first one just deals with more details of the sharing of the information of Trustee Khan's crash videos. And there were some things at the first time that weren't clarified. One of them, and still apparently aren't, and hopefully some of these affidavits will deal with that, because there were findings that did not comport with what the testimony was, which was that this was for legal purposes. There were findings that this was somehow confidential information. These are public records. I have evidence that they can be easily procured through the public. There was many things about that particular incident that were not delved into. And when we saw the decision, it became clear that the trustees had misunderstood that whole issue and what had happened. And again, we think that probably arises from the fact that one of the people making the decisions was in fact the person involved in that underlying issue. He was accused of sharing information for gossip. Again, that was one of my arguments, that that's another gay stereotype, that police officers would be, gay people would somehow be gossiping and for amusement of his husband. There were things that were extrapolated that were never part of the evidence. There was no evidence that he was gossiping. So that had to be dealt with, and it had to be dealt with in an affidavit to counter that. So therefore, that is that first affidavit.
Okay, thank you. Attorney Haste?
Nothing to add except to reiterate my objection that Attorney Selden's first affidavit from July 28th, 2025.
Is that the one that we're addressing?
Yes, I'm just distinguishing it from the second affidavit.
Okay.
That's the one that I'm talking about. Is not relevant for the same reasons that Mr. Blish's affidavit is not relevant, nor the details of the underlying incident relevant.
Thank you.
Your Honor, can we address a tech issue? I'm getting notices that the Zoom is freezing for people that are on the.
Yeah, the internet has crashed 4 times.
How is that legal?
Is it up and running now?
It is up and running now.
I mean, we're doing our best.
Talk about it in the
Okay. If it's running, that's the best we can do right now.
Okay, the other issue is it appears that somebody has been thrown out of the hearing already. I don't know why, I don't know what. I got a notice that one of the members of the gay community, Jefferson Atkins, was not allowed in. I don't know why.
That I'm the hearing officer, and that's not the case.
That's not the case?
We haven't thrown anybody out of it.
Okay. Well, that's the information I've been receiving.
Just hold on a second. Right. What's that?
Would you like to go on as to Exhibit 5?
Yes, I will. That's the second affidavit of Attorney Selden, and this one is relevant because it deals with, again, the different treatment that Chief Swanson has received as opposed to other officers. And yes, it did occur during the time he was unlawfully demoted, but there is evidence, and this is a very significant issue. There was a lot of talk at the first hearing about how inappropriate it was for Chief Swanson to be getting a haircut when he was at work hours, even though he was not the on-duty person. And when Attorney Selden happened upon Sergeant O'Keefe receiving a haircut and getting in a Trustee Blakeman's salon, and that's when the obscene gesture took place as well. But when he saw that and took the picture, we made that clear that this was a very different, the same situation, and Sergeant O'Keefe has had no discipline and has, apparently this is endorsed, that he can, by a trustee in fact, that he can be having haircuts on duty. He's in his uniform, it's in work hours. Unlike Chief Swanson, who wasn't even the duty officer, he was clearly on duty. And therefore, this is relevant to, again, the different treatment that is provided and the different standards. We're here to talk about standards. What are appropriate standards for a police officer? So when you have evidence of police officers he was the interim chief at the time, doing things that Chief Swanson has been disciplined for, that's relevant. And that's why that affidavit is there.
Mr. Hayes?
Just same objection. If necessary, we will respond to everything presented in all of this. We do have responses, but the fact is this hearing is about the 3 letters before the first decision, and this is clearly outside that scope.
Thank you.
Next affidavit, I think is that the last one? No, you got some more. This is the affidavit, since there was so much testimony about the nature and extent of his haircuts, lots of focus on his hair, messy hair, haircuts, hair. So we have an affidavit from his hairdresser that she looked at her records because she was shocked after the first hearing about the claims that he was traveling there, I don't know, all the time. And she looked at her records and determined that he had only been there twice in 15 months during the time period that we were, during the work hours. So that's relevant to the prior allegations.
Thank you. Mr. Hayes?
Just the same general obligation that appears to be no reason why Ms. Walker could not testify and be subjected to cross-examination. Also, I will say that there's no indicia of reliability here, since Ms. Walker states she's no longer an employee of the salon where these records supposedly exist. So it's quite unreliable to say I have some memory of checking some time ago while I still was an employee of this particular location. And so it's just not reliable. But that's all I have to say about that.
Thank you.
My response to that goes to the weight, not the admissibility. So next is the affidavit of Carolyn Clark. Carolyn Clark, actually her name is Carolyn Lord now, I'm sorry. She got married, so her affidavit is actually Carolyn Lord. This is one where there was a great reliance on this no confidence vote being unanimous, and she wrote this to indicate that she was a member of the union that allegedly voted no confidence. She never attended any meeting, and nor was she aware that any meeting was held, and she never voted no confidence. So that's her, under oath, her statement. And I don't know why that trustees wouldn't want to hear that, but sure, we have some objections.
Attorney Hicks?
My objection just the same as to all affidavits of individuals who appear to be local and, or who could testify remotely.
Thank you. Exhibit 8?
Yep, it's also another, actually, another employee, a current employee, Lisa Linton, who says the same thing as Carolyn Lord. She's a member of the union. There's no meeting. And she also adds that the reason she didn't speak up when she heard about all of this being unanimous when it isn't, is that she feared retaliation from her supervisors. And again, I don't know why they're trying to keep that from the trustees as well.
Attorney Hicks?
Same objection to, I mean, she's currently an employee, she could voluntarily come. And also, since receiving this affidavit from Ms. Linton, Mr. Duffy has learned that Ms. Linton did in fact vote with approval by email, and therefore this affidavit is not reliable.
Thank you. Exhibit 9.
Yep, that's the one that is attached to Chief Swanson's affidavit. This is the letter that is dated February 18th about where I asked Matt Bloomer, who is representing or not representing Mr. Duffy, since no one is saying they represent Mr. Duffy, they're all saying they represent the village. So he represented someone, and he's saying that he would check with Eric on February 18th and let me know. I said he's planning to go in briefly. This should not take more than half an hour. I anticipate this will not be an issue. There's nothing else attached to it because I never received a response. That's exhibit. That's that.
We have no objection to this one.
Okay.
Okay, the next one is the copy of the letter. And this is only in here, it was submitted last time, but it's only in here again to show that the address was in fact wrong for Chief Swanson, which is why he did not receive it until February 20th. And in another affidavit, there is, I think it's Attorney Selden's affidavit, he explains that on February 20th, when they received it, there was a Facebook posting to show that that was the first time that they ever saw it. So that's that.
No objection.
Okay. Can you
Exhibit
just
C.
bear with me for 1 second to take some notes?
Yep, sorry.
Exhibit 11?
Yep, Exhibit C.
Or C, yeah.
Yep.
Why did we switch from numbers to letters? Is it because they were last time?
I just made the letters so that we can tab them better, but and there were affidavits which aren't exhibits, so I didn't quite know how to put them. So I think I've made it so we can follow along with both the letters and the numbers.
Thank you.
So number 11 is Exhibit C, which is the traffic court record, which totally disproves that on the one occasion, that the testimony that on the one occasion he was scheduled to go, he didn't go because it shows, well, in fact, at least on one occasion on September 13th, he did in fact go. And we have an email that shows that he was actually there in person because somebody overheard him arguing. So that is that exhibit.
Thank you. Attorney Hick?
I guess I'll just say for the record, this exhibit has not been authenticated, but in any event, it doesn't contradict the testimony that there was one other occasion in July 2023 when Mr. Swanson, in fact, did not go to traffic court. That he went in September doesn't prove that he didn't go in July or that anyone was aware at the time of their testimony that he specifically had gone in September. And that's what I say about that.
Okay.
I would just say that all these records are available to the police department of public records requests, so they clearly have them. And the testimony was on one occasion that he was scheduled, that he didn't go. So that's the contradiction. Whether there were other occasions where he did or did not go, I don't think contradicts this particular exhibit.
Okay. Exhibit 12.
Yep, that's employee letters, Exhibit D, employee letters about not resigning. These are all various letters that were sent either to you, Attorney Monahan, or to the board. I can't remember which one. Some of them, different people, I guess, from various employees after the hearing that heard that they had been represented as planning to quit, and whether they were or were not before, they wanted to clarify that certainly that was not their intention or feeling at this point, so they provided these letters, and that's what that is. And it's, I think there's 6 of them here, is it, or 5? Let me see. There's attorney, there's Sergeant Aurora, there's Josh Linton, Danelle McIntyre, Elizabeth Turco, and who's this? Katrina Porch, so 5.
Okay. Any objection, counsel?
Yes, I do object. The testimony from Mr. O'Keefe at the first hearing, when asked who had indicated to him that they would not remain if Mr. Swanson were to continue on as chief, the answer was, quote, Officer Tarleton, Officer Aurora, Officer Murphy, Corporal Murphy, Officer Turco, Officer Donka, a couple of the part-time folks had made mention. That's on page 236, lines 2 to 5. These emails were also already considered and addressed in the first decision explicitly by the trustees. These emails are not reliable. Mr. Aurora says he did not recall mentioning that he would leave, but he does not deny mentioning that he would leave. He could have changed his mind. It's entirely consistent with Mr. O'Keefe's testimony. It's the exact same for Mr. Turco. The 2 emails are suspiciously identical, and there's no opportunity to cross either of them, nor are those emails sworn. The remainder of the emails from Linton, McIntyre, and Porch, they're not among those that Mr. O'Keefe testified about specifically or named, so they're irrelevant from our perspective.
Okay, thank you. Counsel?
We'll move on. Well, actually, all I'd say about that is, regardless of any arguments, it shows that these officers, when they sent the things, indicated that they were not, in fact, planning to leave, which is relevant because that was one of the whole arguments, that the police department would fall apart because everybody would be leaving. So the relevance is there.
Okay, thank you. Next one?
Yes, Exhibit E, the Rock'em Sock'em toy exhibit. This is, again, presented simply for the standards that are applied differently to Chief Swanson as opposed to Sergeant O'Keefe. Chief Swanson was accused of having a frat-like atmosphere in his police department and having, allowing things that should not be happening, that were not professional. So I think this, again, is just an example of different treatment.
Counsel?
This is covered by my global objection to evidence that postdates the first decision. There's also no indication when this photo was taken, who was taking it, how long it had been there. It just, to me, has no relevance. But if the trustees are inclined to consider evidence that postdates it, to me, it has no such little probative value. I guess I don't really care. The trustees have all looked at it at this point anyway, so it is what it is.
Thank you.
And I would just say that Chief Swanson did discuss this in his affidavit, so he's verified that this was in fact a photo that was taken under Sergeant O'Keefe's command.
Thank you.
Moving on, Exhibit F. This is about a citizen email that went unanswered. It's actually, I think it's still unanswered from, it was to the police department from January 11th, it looks like, up until February 23rd, and the Woodstock Police Department has not answered. This is from a citizen, William Boardman, who sent a list of questions. Nobody ever responded to him. Clearly, again, we're talking about standards of behavior and what is applied. Chief Swanson has been accused of being derelict in his duties and not responding to people. And here we have absolutely evidence that that is not atypical, apparently, in the Woodstock Police Department.
My understanding is that this person is present here today. Is that?
Who?
Mr. Boardman.
I think he is.
Okay.
Why?
Is he available to testify about this?
Why would he have to testify? I mean, yes, he could testify. I think, I haven't talked to him. I've never spoken to the man.
I'm just asking the question because he's present in the room and,
Well, I could certainly ask him. Like you said, nobody can be compelled to testify here.
yeah,
But I can
that's,
discuss that at a break. I'll ask him.
Thank you.
But I mean, if he doesn't want to, he can't be compelled. As you said, no subpoena power.
I understand. Okay, thank you. Attorney Haste?
This is postdates the trustee's decision. There's not any evidence. This is to a general email address. It's not specifically to Mr. O'Keefe or anyone else. That's all I'll say about that.
Okay, thank you.
Okay, so moving on, we're up to Exhibit G, which is number 15. That's an email regarding Sergeant O'Keefe's mishandling of a sexual assault case. And again, this is for the purpose of showing different treatment between Chief Swanson and other officers. This is a serious issue where Chief Swanson was accused of not preserving evidence. We have Sergeant O'Keefe not preserving evidence and mishandling something with apparently no consequences, as opposed to Chief Swanson, who is being terminated partly because of that. So I think it's relevant.
Okay, thank you. Counsel?
This is not an authentic email. It seems to be a copy and paste. Haven't compared it to an original, so can't trust its authenticity. It's also outside of time, and I guess I also want to raise that I have asserted two global objections concerning Mr. Duffy and Mr. O'Keefe's performance in general. Again, I think both of their performance in their respective roles is far outside the scope of Mr. Swanson's performance as an employee. And in addition, these seem to be designed to be personal attacks to, try to embarrass Mr. O'Keefe and Mr. Duffy. If need be, we will respond to this specifically, but it shouldn't be considered as part of this hearing.
I'm sorry, maybe I misunderstood. Did I just hear that this was being construed as a personal attack on Manager Duffy and Sergeant O'Keefe? Was that the argument?
I was just raising the arguments that I put in my letter from yesterday, that anything that concerns their specific performance, I have an objection to on across the board to that, because those issues intersect multiple documents, including this one.
So Chief Swanson can be vilified and attacked and talked about in terms of his handling, but no other officer can be similarly discussed. Okay.
That's not my position. It's outside the scope of this disciplinary hearing concerning this employee. What discipline, coaching, performance management other employees might or might not have received at any point is just simply not relevant to removing Mr. Swanson from his position.
Thank you.
Okay, moving on. Exhibit H is a photo of Trustee Blakeman and Sergeant O'Keefe getting a haircut. And again, I've already talked about the relevancy of Sergeant O'Keefe's haircut in terms of performance standards applied differently to different employees.
Okay.
This is irrelevant due to the timing, and Attorney Blakeman has the right to exercise her First Amendment rights, as apparently was Attorney Selden.
And I would argue that in her opening, counsel for Manager Duffy talked about foul language being used by Chief Swanson and how that was inappropriate. But apparently it is appropriate and an exercise of free speech for Trustee Blakeman. Thank you.
Thank you. Exhibit 17 or Exhibit I.
I think we're on to, that is just an email confirming by Manager Duffy that there is no text messages or emails that were sent or received that he did not send or receive between him and Sergeant O'Keefe regarding his on-duty haircut, that there's no written documents pertaining to any kind of discipline that might have been issued, and also that no policies were instituted as a result of that.
This email doesn't reference discipline. I mean, it speaks for itself. Our objections based on the timing of this. If we lose on that issue, it's fine to admit it.
Thank you.
Okay, now we're getting into Exhibit J. Is that what we're up to, 18?
Yes.
That's again about the involuntary administrative leave and the discrimination and bias that Chief Swanson was subjected to while he was an unlawfully demoted officer. And you know my arguments about that is that this is further evidence of bad faith, bias, discrimination.
Thank you. Counsel?
Same objection, it's irrelevant based on the scope of the time at issue. If we lose on that, it would be fine to admit it.
Thank you. Exhibit K.
Okay, Exhibit K, probably our most extensive exhibit here, I think over 60 pages. These are complaints about Manager Duffy from former employees, from the public, and again, the relevance is that different standards are being applied. When Chief Swanson's employees complain about him, it's cause for termination. When Mr. Duffy's employees complain about him, it's cause for celebration. It's cause for bonuses, raises. It's a completely different standard being applied to Manager Duffy and Chief Swanson in terms of public outcry, in terms of employee complaints, and these are various documents that indicate people have in fact been complaining about Mr. Duffy, and it's all gone ignored. And the other, so he's been complained about. There's not one thing that I could find in any public listserv of any complaints against Chief Swanson. And these were all about Mr. Duffy and the community being outraged about some of the things that he's done, not just in regard to Chief Swanson, but in general. And again, no action taken against Manager Duffy, and Chief Swanson vilified for when just a few employees at the behest of Manager Duffy came to testify.
Okay. Thank you. Counsel?
Same objection I mentioned earlier. Mr. Duffy's employment is not at issue today. Only Mr. Swanson is. There's no evidence any of these documents were ever reviewed or considered by Mr. Duffy or anyone. I also want to note that the last few pages concern confidential personnel matters that are not being adjudicated in any way today, and would therefore object on that specific basis as well.
Which pages?
The final, not numbered, but 1, 2, 3, 4.
That's an exit survey by Corey Frederick, who talked about Mr. Duffy not caring or appreciating about his staff, that he thought they were all expendable, and that they voiced concerns. Obviously, if I have this, it's not confidential because it was provided in some form. I don't know how, but there it is. And Corey Frederick, who wrote this, clearly hasn't objected, so I don't know what the problem is and why. And obviously, the trustees obviously have this. It's an exit survey that should be in the file, and they should already have it. So why would it be a problem to have it be introduced here?
I just have no basis to verify Attorney Cross's assertion that anyone does or does not object, and on behalf of the municipality feel must err on the side of keeping employee personnel matters, including HR documents, confidential as a default.
Thank you. Exhibit L.
Oh, okay. This is Kenneth Cooper's complaint regarding Mr. Duffy. And again, this shows that a year went by where a citizen complained to Mr. Duffy about an issue, and Mr. Duffy did not respond for a year. And Chief Swanson is being accused of failing to do paperwork, failing to respond to community members. And here we have an exhibit that shows a year late, 3-line response. And Mr. Duffy apparently believes that simply apologizing was sufficient for him, but for Chief Swanson, it's cause for termination.
Counsel.
This is irrelevant for the arguments I've made previously. The role of a town manager and the role of police chief are different, and Mr. Duffy is not here to defend every single action he's taken in his employment. But even so, this is outside the scope. This doesn't demonstrate anything. Mr. Duffy apologized for his oversight in the document.
Thank you. Exhibit M.
Yep, these are the underlying documents for Trustee Khan's road rage incident. And what they're here for is to show that there was, in fact, a dispute about that, who was at fault for that. And Trustee Khan did, in fact, ask that that ticket be dismissed, and Corporal Murphy did, in fact, dismiss it. So it shows that this was not a clear-cut issue. This is something that was underlying and that there was dispute about. Trustee Khan did, in fact, dispute it, and Corporal Murphy did, despite the differences in opinion about who was at fault, she did, in fact, dismiss it for Trustee Khan, and that's why that is there.
Okay, Counsel.
This is entirely irrelevant. The underlying incident was only introduced because Mr. Swanson inappropriately shared materials he obtained solely in the course of his employment with his spouse. These documents have no bearing on whether, as Mr. Swanson and Attorney Selden have alleged, that communication between spouses was also a legal consultation. You can review the emails for yourself.
Okay, thank you. Next.
Moving on, Exhibit N. This is an investigation that was done by Fire Chief David Green, and this is, again, to prove this is relevant to the timeliness of responses within the Woodstock Police Department and the different treatment that Chief Swanson has received as opposed to Manager Duffy or Sergeant O'Keefe. It looks, you can tell from the dates in the letter that the complaint was received on June 26th, and it was not forwarded to anyone to even look at until August 11th by Manager Duffy, and then it was discussed with Sergeant O'Keefe about why he never responded to the person who had made the complaint, and he hadn't responded, he said, because there was no policy in place. He didn't know that he needed to respond, apparently, and so there was this delay from June to ever, I guess. He never responded because he thought he didn't have to. But when Chief Swanson did something, if he ever did anything like that, that would absolutely be considered grounds for termination. But here we have the memo. Apparently, there was a memo outlining expectations for employees, but Sergeant O'Keefe said he hadn't received the memo. So because he didn't know, apparently, that he was supposed to respond in a timely manner, there was no issue and no procedural violation was alleged because he didn't know. And that goes exactly to what was alleged against Chief Swanson, which is that he somehow should have known things that were not specifically written out to him.
Thank you. Counsel?
This is irrelevant to the core issue of Mr. Swanson's employment. It's just a sideshow, frankly. Complaints by Mr. Swanson's spouse concerning Interim Chief O'Keefe's responsiveness to Mr. Selden has no bearing on Mr. Duffy's reasons for potential employment actions, including removal through demotion, that we're here to address today.
Okay, thank you, Counsel. Exhibit O?
Yep, Exhibit O is Manager Duffy's new contract. This is relevant for a number of reasons, Attorney Monahan. It is relevant because, again, to the same thing about bias and professional standards. When we look at this contract, we see that Manager Duffy has written in, for himself, he has written in specific protections that he is denying to Chief Swanson. Chief Swanson had a progressive discipline personnel policy when he signed his initial employment contract, allowing for progressive discipline, verbal warnings, written warnings, that kind of thing. And when one of Mr. Duffy's arguments is that, no, that doesn't apply. Chief Swanson is not entitled to any progressive discipline, any notice at all. It's fine that he had no notice of all these things because it's the new policy that should be in effect, the one that he took out progressive discipline. But yet, here we have a contract that Manager Duffy has, in fact, written in for himself under page 4. If you look at page 4, you look at the page 4, number C, 4, he has written in for himself in his contract that if he's accused of any kind of negligence in his performance of his duties, if failure to perform his duties, if he is in fact accused of that, it's the last sentence in C. If he is accused of that, he is allowed 30 days. He can't be terminated for cause unless he is given 30 days notice of whatever negligent performance he has allegedly committed. So this is evidence of a different standard, a totally different standard. And that's not just the only thing. He's also put in this in the same paragraph that his conduct, if he's terminated for cause, it has to be a material act of misconduct in connection with the performance of his duties, not these minor things like that Chief Swanson is being accused of. If Attorney Duffy is going to be removed for cause, he wants to make sure it's for a good reason, for material act of misconduct. This shows, again, the bias, the discrimination, the homophobia that I was talking about earlier. Two different standards for a chief and a manager.
Thank you, counsel.
There are in fact different legal standards that apply to a town manager and a chief. As a town manager, Mr. Duffy is not subject to section 1931 or 1932. The Vermont Supreme Court has been very clear that different standards apply to law enforcement officers in general and when directly construing those statutes. On the comment about policies change, they do change. They did change here. Mr. Swanson had notice of the change of the policy because he signed the document indicating he had received it. And Mr. Duffy did not write this contract, and there's not any evidence that he did. And to try to say this is Mr. Duffy treating himself differently than Mr. Swanson is just inaccurate. And also, again, Mr. Duffy's employment relationship with the municipality is not in any way at issue here today.
Thank you.
Okay, then I
There are
think we're
some
getting
others.
onto my second, my supplemental ones here. Let's go to those. So we've got, so Exhibit P is because I realized when I looked at the former transcript that both of the letters were not included in the original exhibit. Only the one that said unanimously taken a formal vote was included, and somehow it was neglected that the second one, which contradicted it, said or didn't include the unanimous, that both of these were given to Mr. Duffy, but only one says unanimous, and they were not included originally, so that's what that's about.
Okay,
No
counsel.
objection.
Exhibit Q is the letter that was written on behalf of Mr. Duffy informing Chief Swanson for the first time of the allegations against him. And this is for the purpose of showing that at this time, these allegations that were made against him were before Mr. Burgess had completed his report. So these were ones that Manager Duffy, in fact, came up with as a non-police person on his own.
No objection.
Exhibit R is the response from Chief Swanson's attorney at the time. His response to the attorney at the time was, it shows that the attorney absolutely requested information about whether this had been sent to the Vermont Council for Criminal Justice and asked that it be done and wanted to know the status, and that Mr. Duffy obfuscated, never ever told for months and weeks, months, until Chief Swanson got that letter from Vermont Council. He didn't even know that it had been sent, but this shows that Manager Duffy was on notice that this had been requested and he withheld it.
I don't think that's what this document shows, and I don't think that an advocacy letter from an attorney on behalf of their client is appropriate testimony. This isn't a communication to or from either party. It's between counsel, it's legal argument. I just don't think it's relevant.
Thank you.
I would just point out the sentence on page 4 saying, "We are requesting a paper trail confirming that the complaints against Chief Swanson were referred to the council." November 27th. Completely ignored, never provided.
And again, this wasn't addressed to Mr. Duffy specifically. This is lawyer to lawyer, which I generally think is too far outside the bounds of what's relevant here. Attorneys advocating on behalf of their clients is not evidence generally.
Okay, thank you.
Exhibit S is the internal affairs policy. Again, this is one I realized didn't make it into the original exhibit. This is relevant. It talks about the appropriate procedures. It has sections where investigator is supposed to sign under perjury. Mr. Burgess never signed anything under perjury. It also says that the purpose is to protect all employees from inaccurate allegations of impropriety. It didn't make it to the first hearing. I don't know if there's any objection to that.
No objection to the admission of police department policies and procedures in general.
Okay, thank you.
Exhibit T, I think we're at the end. Exhibit T is about, the reason this is in here, again, is different treatment for different employees. Manager Duffy holding himself to a different standard. He tells the media after the decision is made by the court to reverse the demotion, he, in the process of trying to obtain a new job in Woodstock, he is interviewed, and here's a quote that is directed to him, never corrected as far as I can tell, that says that they spoke with Manager Duffy, and he said, "We believe," about Chief Swanson, even though the court reversed him, he's saying, "We believe he was unable to perform his duties as chief." So he's speaking on behalf, and that's on page 2, second paragraph. He's speaking on behalf of the village, saying defamatory things against Chief Swanson, completely inappropriate, against policy, against personnel policies, saying that you cannot defame other members of the other employees, and yet unchecked, rewarded, given more money, and no consequences.
I think this is exhibit covered by my previous objections. I mean, so I'll, rather than restating them, just rely on my previous arguments concerning Mr. Duffy's employment, efforts to seek other employment, et cetera, are just simply not relevant. Nor is, in my opinion, what he wrote or what the quote attributed to him necessarily inaccurate.
Thank you. All right,
we've
that's-
come to the end of the
Okay.
exhibits. And all I will ask is that if whatever is ordered, the ones that, if any are excluded, that they please be marked as ID for the appellate review.
Understood, thank you. I think it's a good time for us all to take a break. The board will discuss and we'll come back. And normally I was gonna say a 15-minute break, but I think we'll need at least a half hour to get through this stuff. So we'll plan to be back here at 10 after 11, but it may be longer and I may come to let you know. Thank you.
Thank you.